For those who are just joining us, if you could go ahead and complete our poll, and we'll start in just a minute. All right, I'm going to go ahead and end this first poll because we do have a second poll. So you can see the results here. About almost half of the people here are California attorneys, and about 19% are attorneys outside of California, and then 33% are non-attorneys. And then our second poll is right here. So go ahead and complete that poll, and then once we're done with that poll, we're going to go ahead and get started. All right, so as you can see from our second poll, we have about 69%, or exactly 69% of you are currently working on a vacatur petition right now or have worked on one in the past. So a few introductory remarks, and we'll jump right in. Everyone should default to muting you and default to not having your video on. If your video is on, you're welcome to turn it off during the plenary panel. However, when we go into our breakout sessions, the default is going to switch. So you're going to go to unmuted and your video will be playing. You can always turn your video off. The goal is that this is an interactive discussion, so we want you to be able to participate actively. So this is a little bit different format for those of you who have attended our webinars before. As you can see, this is set up more like a Zoom, it's set up as a Zoom meeting as opposed to a webinar, which is just a one-way program. This is two ways. If you can and would like to, and it'd be great if you could add your affiliation and also your state to your name on Zoom. So you could just go to your name in the participants side of, you click on participants at the bottom or top of your screen. You can right click on your name, click more, and then rename yourself. And that way we'll, especially as we're engaging in our interactive dialogue, people will have a better sense of your affiliation and also what state you're in. And also, if it might be easier to view this as speaker view, so you can only see the people talking since there are a lot of participants. And lastly, if you are a California attorney, we will send out MCLE certificates after. With everything with COVID, state bar approval is a little bit slower than normal, so we'll send them out once we have those. So with that, I'm going to give you just a quick overview of what we're doing today. Thank you all so much for attending. I know this is a long session, and the reason is because we really had a lot to talk about, and we wanted to have enough time to dive really deep into this issue of vacatur in California. if you, hopefully you've seen our Vacatur training or seen another Vacatur training prior to this. We are going to assume from the outset that you have received training on Vacatur, and we're not going to do any of the basics of what is Vacatur. Some of your speakers may just touch on things briefly at the beginning, but there's an assumption that you already have that background knowledge. And so we're going to start off today with a plenary panel discussion. I'll introduce our panelists in just a minute. Then we're going to have a quick stretch break, which is also during that time, you're going to transition into breakout groups. We're going to have breakout groups for about an hour, and then we'll have another transition stretch break. And then we'll go back into our large group, and we'll share key takeaways. And, you know, like, as I mentioned, our hope is that the breakout groups really are an interactive dialogue. We have a whole group of co-facilitators that are all experts in this area as part of the breakout sessions, and we have a whole set of questions for them, but we also encourage you to ask your own questions. And one thing that I'll just say from the outset is that we all, those of us who've been doing Vacatur have all been learning this real time together, because it's something that is a very new area of the law, particularly in California, and so there's a lot of learning for all of us, and so I'm really looking forward to hearing from all of our experts, and I hope you are as well. And then at the very end, we'll just talk about moving forward and wrap up. So with that, I'm going to introduce our plenary panel speakers today. I'm the moderator. My name is Jamie Beck, and I'm the president and managing attorney of Free to Thrive. We provide legal services and other support to survivors of human trafficking with a focus on San Diego. Our speakers today are Mary Ellen Barrett, who's a deputy district attorney here in San Diego, and she is the human trafficking team leader in her office, and her office's Sex Crimes and Human Trafficking Division. She's also assigned to the San Diego Trafficking Prevention Collective. Next, we have Catherine Brainer, who is the Chief Deputy of Development and Training for the San Diego County Office of the Public Defender, and created her office's Fresh Start program. And last but certainly not least, we have Kate Moglescu, who is an assistant professor of clinical law and directs the Criminal Defense and Advocacy Clinic at Brooklyn Law School. And she's also the founder of the Survivor Reentry Project. So with that, I'm going to welcome our panelists. Thank you so much for being here today from near and far. And first, I'd love it if you could just start off with giving us a brief introduction of background on how long you've been doing Vacatur work and in what capacity. And I'll start off with Kate Brainer.
Hi everyone, I'm Kate Brainer. I am a 25-year veteran with the San Diego County Public Defender's Office. Over my career, I have represented in both delinquency court and adult court, victims of human trafficking and traffickers. I kind of fell into doing Vacatur work. I started a program in our department called Fresh Start, which is designed to help people clean up their criminal records. And in the course of that, I was following new legislation and stumbled across this bill, this Vacatur bill. When it passed, I was super excited. I had no idea what it meant or how it was going to be implemented, but I gathered around me really smart people, including Jamie and Kate and Mary Ellen, and we learned about it, and we started implementing the Vacatur law here in San Diego. So that was in January of 2017, right?
Thanks so much, Kate. And now I'll go to you, Mary Ellen.
Hi, everyone. I'm Mary Ellen Barrett. I'm a deputy DA. I have been a DA for 30 years. I've been working in the human trafficking space since 2012. And when this came out, the law passed, Kate reached out. What she left out was she was ahead of the game, and we started planning for it. Since it passed but didn't take effect until January, we spent that time at the urgence of Kate getting a procedure in place so we'd be ready to go as soon as the law was in effect. And since then, I've been handling it, and I'm the only one in our office that does it. So for consistency's sake, but we were able to get the DA to buy off on just having one point of contact.
Thank you, Marilyn. And that's been a huge help for us in San Diego to have a single point of contact. And last, Kate Mogilescu. And I will say that I imagine that for anybody here doing vacatur work, you have been impacted by Kate's work on vacatur, whether you know it or not. She has trained most of us. She's the person who gave me the idea to advocate for me and the Lawyers Club of Human Trafficking Collaborative to advocate for this law in California, and has been leading nationally on this issue.
No, that's very kind, Jamie. Thank you. Hi, everyone. I'm Kate Mogilescu. I am on the East Coast, so this is going to span my dinner time. So my level of sort of crankiness, which many of you already know very well, will likely increase as we move through the evening. But I'll try to have a snack when we do our break. I also would point out the remarkable phenomenon that if you haven't noticed already by looking at the presenter lineup here, that overwhelmingly people who are doing really good work advocating for trafficking victims are named Kate. And our public defenders named Kate, with some social workers thrown in there. I'm looking at you, Kate Kimmer. These are just points that I think we should all acknowledge as we get started. Framing is always very important. So I run a law school clinic now in New York City that represents survivors of gender-based violence, including survivors of human trafficking who have been criminalized. So survivors who are facing prosecution, who have faced prosecution, are dealing with the lasting impacts of having been prosecuted. And a lot of this work started in the public defender's office in New York City about a decade ago, when New York's law for trafficking survivors first went into effect. And like many others have said already in the short time, we had a law that we had no idea what it actually meant or would look like in practice. And so spent many years after our law was passed in New York just shaping the practice, together with many people who are in attendance and participating here today. So I come at this from a public defender perspective, and like Kate Brainer, thinking about just the consequences of criminal records on people generally, and how influential and impactful the ability to remove things from a criminal record, whether for a trafficking survivor or for anyone, can be in terms of people's ability to move forward. And so I think that has framed a lot of our approach to this over the years.
Thank you, Kate. And I'm actually going to stay with you for our first substantive question, which is, when we first met back in 2015, I recall you saying that 11 states had vacatur laws. Since that time, many states have joined, including California, to add this to their laws. And I was hoping that you could tell us how many states have vacatur laws, and how have the vacatur laws around the country evolved since you started doing this work?
Well, it's been really remarkable to watch over the last decade as these laws have proliferated across the country. So right now, almost every state in the US offers some form of criminal record relief to trafficking survivors. The states that do not, which we can name and shame, are Iowa and Virginia and Maine and Alaska. But interestingly, watching the progression of legislation in this area, we keep learning and we keep evolving the practice based on what we've learned. So as many of you know, New York's law, which was the first to be passed, still to this day actually on the books applies only to prostitution offenses that survivors might have on their record. But as many of you also know, survivors are criminalized for a whole host of offenses connected to their victimization, not just prostitution. And so many of the laws that followed New York's have gone further than New York's have, and allowed survivors to vacate a range of offenses, including, for example, in California, nonviolent offenses. Georgia just passed a law a few weeks ago that went into effect the beginning of this month that applies to all offenses that were a direct result of trafficking. And while I know that's going to lead to some very complicated and sort of tough circumstances for us to tackle collaboratively, it certainly seems to be a step in the evolution of our understanding of what survivor needs are and how the court system needs to be responsive. So we've really seen quite a sea change over the last many years in terms of legislation in this area, and then people on the ground working to make sure the relief actually meets survivors.
Thanks, Kate. It's really been exciting to watch. And to your point of there being many amazing Kates, which I completely concur with. Kate Brainerd, the next question is for you. So San Diego Public Defender's Office has been doing vacatur work since the law went into effect, and as Mary Ellen pointed out, actually before it even went into effect, but after it became law. And I'm hoping you could share with us what are some of the lessons that you and your team have learned in the last 3 years?
I'd say 2 takeaways are patience and persistence. Patience, why do I talk about patience? Need to have patience with clients. This is going to take a lot longer than you expect. It's going to take longer working with the client. It's the process itself is going to take longer than you expect. Patience with clients, it takes time to draw out their experience. I think many people who are lawyers expect that when you sit down and you start to interview someone, they will just blurt out their experience and share it with you immediately. We're confidential, it's all secret, you can tell me anything. It takes a really long time to develop the rapport with certain clients so that they will feel comfortable in sharing with what they perceive as a complete and total stranger their experiences. And their experiences that we need to know about start from childhood and move forward to where they are today. So it's a lot to cover. I also, one of the big takeaways we've learned when we think about patients with clients is there is sometimes the clients drop off. We lose track of them on occasion. And I don't want you to take that personally. It is not personal. Our clients, even though they have come a long way, still lead very complicated lives. They may be housing unstable. They may be employment unstable. So a lot of times just other factors in their lives overwhelm them, and they may not have the energy, the emotional and physical energy to be working with you on their vacatur petition at that given time. Another aspect of patience is they may not show up to appointments or return phone calls, not because their lives are complicated, but that because going through this process can be very traumatic. It takes a lot of emotional energy for them to go back and relive these experiences to be able to share them with you. And sometimes they are stronger and sometimes they need a break from this, and they may not know how to communicate that to you. So patience with your clients in the sense that give them the time that they may need. Sometimes they may be more engaged or less engaged with the process. Also, patience with the process of filing these petitions and getting them all the way through the system. Hopefully in your jurisdiction, you can develop a kind of a tiger team, if you will, on getting these petitions through your jurisdiction. I firmly believe that if you've got a prosecutor, like we've got Mary Ellen Barrett in our district attorney's office, who's very knowledgeable about these issues and wants to take responsibility for handling these petitions, that is ideal. You've got to get a judge who is knowledgeable about these issues, interested in handling these petitions, at least at the beginning. You need to engage all the stakeholders, your justice partners, in the process so that you can develop a process that will make in your jurisdiction that makes it a little smoother. When I'm talking about your justice partners, I'm talking everybody from the court clerks who may be processing these and need to learn the process to sometimes your police agencies, if they need to understand about how to vacate things. There are so many players that will help this process become much more streamlined if you engage them up front and you create your tiger team. I also talk about persistence, not only in building those relationships with your justice partners to be able to streamline a vacatur process in your jurisdiction, but persistence in actually getting the record vacated. For those of us who've worked in this field, I was so excited the first order that we got, and Mary Ellen and I worked on it together, and we're like, yes, we've done it. We've got the order signed. It probably took at least another year to actually effectuate the order, to get the record sealed in all the places that it needed to be sealed. We'll talk more about that later on in this presentation, but those are my key takeaways: patience and persistence.
Thank you. And I second everything that you said from our perspective at Free to Thrive. Very, very, very true. Mary Ellen, we're gonna dive deeper into this question during the breakouts, but I'm hoping you can touch on what are the key points that you're looking for when evaluating a petition for vacatur. Particularly the net for us in California, the next, we call it like the nexus cause, but the nexus between the trafficking experience and the charges on the record. But if you could just also speak generally about what you're looking for when you're looking at these petitions.
Sure. I'm going to steal the word from one of my colleagues who's on the call. Authenticity, right? Is it true? Is it real? Does it fit within what I have learned about what the life is? And to Kate's point about knowing the childhood, are there red flags that I now know about in that childhood? I've seen that. And from a prosecutor's standpoint, would what I'm looking at be evidence of force, fraud, fear, coercion if I could prosecute the trafficker? Right? Is that evidence of the trafficker's control over the victim? That the victim is unable to hold on to money to get food? That the victim is unable to purchase body wash? That sort of thing. And so then there's the petty theft aspect. So is it the natural outcome of the situation the victim finds himself or herself in? And that varies person to person, right, and case to case. And one thing I will say, talking about partnerships, as Kate mentioned, we have a very strong survivor leader community in San Diego. So to the extent that I might be ignorant in how something works in the life, or that a story fits when I don't think it does, I'm able to go to those experts and, you know, confidentially scrub all the names and all that, but say, when you were in the life, or when someone's in the life, do you sometimes have to steal body wash to get by and still make your quota? Well, yeah, okay. Now I've learned something, and now I can use that lens to look at the petition.
That's really helpful. Thank you. This is a question for all of you, and I'm going to ask Kate M. to go first. And that is, in the tough cases where you're unable to reach an agreement with prosecution, or in your case, Marilyn, with the defense attorney, how do you approach those cases? What advice do you have for attorneys in that situation?
This is an area that we're still developing in so many places. And I think one of the things that we've been able to do across the country is deal with those cases where there's consensus, and the cases where the connection to sex trafficking in particular is very evident to all involved. So prostitution offenses or offenses that are very prostitution adjacent, but where we get a little bit further away from that and further away from the sort of narratives that we confront in trainings all the time, and the sort of very typical trafficking experience that's presented as if there were such a thing, where we then begin to bump up against, I think, more resistance or potential disagreement. And sometimes our tendency to revert back to some of the more predominant narratives, even if they're not the narratives that capture everyone's experience, can hamper us in really thinking through different survivors' experience. So when we reach a point where we're not coming to an agreement with in my case, a prosecutor, or in Mary Ellen's case, a defense attorney, although I don't know that Mary Ellen would be pitching something to a defense attorney in the form of criminal record relief that a defense attorney wouldn't go for necessarily. Mary Ellen wants to vacate everything, and the defense attorneys are like, no, keep some of those charges on their record for sure. But in those instances, we have to sort of build the same sort of practice, even when we disagree. And this is something that I'm really glad that Carolina Holderness from the Manhattan DA's office is joining us today, is here, and is going to be part of the breakout sessions, because we talk about this all the time. We do not always agree. There are cases where we just sort of either, whether it's because of constraints in the law itself in New York, or other issues with what's being presented, we don't end up in the same place. But there are a couple of things that govern our work that make it manageable for the survivors that we're working with, regardless of the outcome. One is, throughout the process, they are treated with respect and dignity. So if there is any part of this that includes a debrief or an interview or an in-person meeting with a prosecutor, that the prosecutors that are doing those meetings are not only trained. When we say trained, that could mean a lot of different things, but that really are just able to be human beings in a moment of interacting with someone who is sharing something with them. Whether or not that's ultimately sufficient to get relief under the law is a different question, but dignity and respect are key to that. Having brought clients in for debriefs and proffers in many different instances in my life as a public defender, that is not usually the tone. This is a very different scenario. Often prosecutors in a standard debrief are looking for ways to show that a defendant, a person charged with a crime, is being untruthful or inconsistent, or, and pulls apart at what they share in a way that is calculated to sort of assess credibility. And that is not the way Carolina approaches the interviews that she has with the survivors that we work with, and it certainly shouldn't be the way. Again, even if we don't reach agreement on the ultimate outcome, the process can be full of respect and engender dignity for the people involved. And that translates then into the courtroom. So if we are appearing in front of a judge and a prosecutor has to take a position that's contrary to the relief that a survivor is seeking, there is a way to do that without making it hostile or personal. And again, I think one of the deep shames of the criminal legal system is that so often we fall into that in our adversarial practice. Even those of us who think we're kind of above it and better than that fall into it quite a bit. And so trying really hard to avoid that here in this process, again, regardless of outcome. Every person that leaves this process should feel that they've been fully represented by an attorney that listened to them, that did everything they could, and that didn't conjure up every single experience that they've had with bad attorneys throughout their lifetime. And for many people who have been system involved their whole lives, all of their experiences with attorneys have been bad, right? From whatever system, not just in the criminal legal system. And so changing that sometimes can be a very powerful thing in and of itself, regardless of the ultimate outcome of the case. And then thinking about how we as a community that deals with the issue of human trafficking expands our notion of what human trafficking is. And that we don't just get stuck in cycling through the same sort of scenarios and hypotheticals and then imposing those standards on survivors. And so those are honest conversations that we have both when we're working on a specific case, but also outside of specific casework about what are we really talking about. And when we say coercion, and we think about coercion, for example, through the control of access to drugs, right, which is a very standard way in which people are coerced into sex work and other forms of labor. How do we understand that? How do we show that? How do we work as a community on that? So I think there are a lot of things that we can do collectively, even when we do not end up agreeing, that make this process safe and okay, and ultimately we're not doing harm to survivors who are coming forward and seeking relief.
Okay, Mary Ellen, how about from your perspective as a prosecutor, when you don't reach an agreement on a case, how do you approach it, and what advice do you have for other prosecutors or for defense attorneys in that matter, for that matter?
I'm fortunate that it hasn't happened really in San Diego. There have been differences.
Unfortunate.
Yeah,
Great.
well, yeah. We've been able to reach a middle ground. So open, honest communication with the petitioner's attorney. But I would second Kate M's statements about, because I've had to think about what's it going to look like if I have to go in on one of these hearings, right? I am used to cross-examination, but you know, absent somebody full on lying, but I can't even imagine going through this process if you're absolutely lying about it. I don't want to rip somebody apart on the stand. So how can we be trauma informed and respectful in that process? And the way Kate said is perfect, so that even if the decision is not going to go the way that the petitioner would like it to go, that they feel heard. And yeah, so I just think it would be ugly to go in and really, like you said, Kate, to fall into adversarial roles. And one part that we have in San Diego, in talking to the presiding judge, he made us, at the time when we made this deal, he made us promise that if there were hearings, he wouldn't have to hear them all. But the one request both Kate Brainer and I made was, that's fine. You can send us out to another department. I get it. We get it. But just make sure it's somebody who knows about this crime and knows what's going on. Because that's the other thing. You don't need a judge up there being uninformed about this and looking at the victim like they've been looked at before. Let me just put it that way, right? That helps no one.
Thank you. And Kate Brainer.
I think if you're starting to work with a client and you're seeing some issues with where this petition could be going, be honest with the client, be honest up front. It is perfectly fair to say, we will try. I can't make you any promises, but here are the challenges that I see with your petition. Because if you're honest up front, again, you're building that rapport, you're getting an appreciation of how challenging this process can be. And you can work with the client explaining that, at least in California, we bear the burden of proof. It's a relatively high burden of proof. It's not outrageous by any stretch of the imagination, but it is a relatively high burden of proof. And that in this process, even if we don't prevail, their voice will have been heard and it will have been told respectfully, and their experience will have been acknowledged. The fact that a petition may not be granted does not mean that their experience wasn't traumatic, that they are not a victim. It could be more that we're lacking, for example, one part of an element. And if you're straight with your client up front where the challenge may be, then you're managing that client's expectations, and you're also acknowledging for yourself the challenges you're going to have as the lawyer, as the advocate. Just because a vacatur may not work, please also don't forget there are other remedies to help them clean up their record. And so if your vacatur petition isn't going to work, fall back on motions to reduce to misdemeanors, fall back on expungement statutes. Think outside the box and go to your prosecutor and say, yes, I know normally you wouldn't 17B this, but taking into consideration everything that this person had been through, you can understand why their conduct happened, even though it doesn't fall into the vacatur option. We really should take a look at this and see if we can do something creative for conviction relief. And so we have other tools available if vacatur is not going to be the answer to help this particular client. And don't forget about those. Reach out to people who are experts in this area, because again, we can help facilitate other options.
I think also just one other point of practice that we can try to build in different jurisdictions, and this is certainly not the culture in the criminal legal system at all, and so this would be a radical act in and of itself, is more information sharing. And so, for example, if I'm working on a case and I'm starting to understand the client's experience and sort of what I need to pull together surrounding the arrests and convictions in question, it takes me as a public defender a lot more time and energy to try to gather police documents or court records than, for example, a prosecutor could gather. Things that are at the tip of, Mary Ellen's fingertips take me a FOIL request and begging clerks and making best friends and a lot of cupcake bribery in different places. But so thinking about our working relationships with each other and with the various other agencies, how do we improve information access so that the process doesn't necessarily have to take as long for survivors, and that we're not spending many, many hours as advocates and public defenders trying to get police documents that are easily accessible otherwise. And that can cut a lot of different ways, right? That can help us identify gaps in a case, places where we're missing corroboration or evidence that's really important to focus in on, and then we can pursue other avenues, or it can very conclusively establish things that would help all of us get on the same page. And so thinking about ways to share information, and this is, again, not standard practice in criminal proceedings or in criminal record, expungement proceedings either, right? And so reworking that and saying, well, what is the harm in making police reports where this person is a named victim accessible to them, rather than them having to go through an administrative process that is difficult, cumbersome, and takes a lot of time.
It's a really great point, Kate. And Mary Ellen has been extremely helpful in that regard, in providing police reports and documentation to us, and especially in those complicated cases where we don't want any surprises once we've already filed. It's been incredibly helpful, and for all the prosecutors on here, I really, really hope that you can take that same approach, because it'll make everybody more successful.
One of the benefits that I have had being the point person here, and honestly, I think I've handled all but one, and I had a conflict on that one. I've had to think through these issues already, right? So it's not going to the new prosecutor all the time. And I actually took it up to my hierarchy to make sure that they're on board with how I'm analyzing the cases. And I think that really helped, because the way we're looking at it is you're entitled to discovery as the lawyer. I have to redact stuff, right? Because I can't give out personal information, but many times what you need is not going to be in the redacted portion. And even if it is in the redacted portion, I've read it. So we're all good there, right?
And I think that's so important. This idea that in this space in vacatur, we really should all be working towards the same goal. Prosecutors should want to facilitate these in the right cases. Prosecutors should be on board, because you have all worked with victims of human trafficking when you've been prosecuting the traffickers. And so you know the damage that it causes. You know the trauma that these individuals have experienced. And I would hope that you would be motivated, just as motivated as you were to prosecute the trafficker, to help vacate the records of the victims.
I would say that sorry, Mary Ellen, but for places that don't have a Mary Ellen and don't have a Carolina, which is most places, because I think there's probably only one Mary Ellen and probably only one Carolina, but in thinking about, those places where either there haven't been a number of criminal record relief cases, and so the practice isn't that well along, or this just isn't the culture and the tone of sort of the advocacy at this point. We do have some resources that help facilitate the prosecutor's perspective on this, which is critical, as you've heard already so far. And so the Survivor Reentry Project has both a report called Workable Solutions, which is best practices for prosecutors working on criminal record relief cases. And I believe that's available in the materials to all participants. And also, if you need a little push, a little public service announcement, we have a video that prosecutors from across the country that are working on criminal record relief cases and have developed those best practices talk about the importance of this. So in places where maybe a prosecutor's office is less familiar, it just hasn't come up, or it's not part of the of the practice yet, those could be very helpful tools in bringing people along and getting to this point of collaboration that you're hearing about in the jurisdictions that have been doing this for a while. So all of those are available on the Survivor Reentry Project website, which is now at Freedom Network USA, and someone maybe can share a link in a Google chat, which is something that is beyond my capacity in this moment.
So we will be providing that report that Kate referenced. It will be part of the written materials, but we can also provide it in the chat. And I'm going to nominate Nick to figure out how to do that. And so that actually was a perfect segue, this whole discussion, to my next question, which is Kate and Mary Ellen both refer to this like amazing kumbaya collaborative process that we've developed here in San Diego that makes me feel very fortunate to practice here in San Diego. I'm wondering, what advice do you have for people in other places about how did you get there? I mean, how do you convince a judge, a prosecutor's agency, to come alongside and create some sort of collaborative process? And if you could give, I don't think we've fully outlined what that process looks like. So if one of you could just give a high level, here's our process in San Diego. It's a very different process, I think, than other places. And then what are the steps you took to get there, or what advice would you give to somebody else trying to create a similar process in their jurisdiction?
So the process we developed in San Diego, we were fortunate because Mary Ellen is an expert in human trafficking, and she has worked in this space for so long. So she was the natural person to invite to the table when we wanted to develop a process. Because she understood that this is a process that we need to protect the privacy of the clients to the greatest degree possible and avoid re-traumatizing them, we came together, and basically what we do is prepare the declaration, the points and authorities, the entire packet that we would normally file in court, but we don't. We send it directly to our prosecutor for her eyes only. It goes directly to Mary Ellen. She then reviews the full detailed packet. And my packets, when I send them over, are usually about 1/4 inch thick or so, sometimes 1/2 inch, depending on how complex the case is. She will then review that material. She does her own independent investigation of the collaborative material, or the corroborating material that I've submitted. She will do her own I've had her reach out to prosecutorial agencies in Alabama, I think it was, on a case, because my client had been a rape victim as a child when she was a child in the South, and I couldn't get those records, but she did that work. And after her due diligence, after her review of all the materials that I submitted, we'll have a conversation, and if she still has other questions, I can answer those questions and provide additional material if necessary. But we get to a point where she says, yes, I am prepared to stipulate to the granting of this petition. What I then do is prepare a petition that is literally 1 page, and it has just the elements of the statute. That is my client's declaration. I was a victim of human trafficking. I committed X number of nonviolent crimes while I was a victim of human trafficking. As a direct result of being a victim of human trafficking, I have removed myself, I've made a good faith effort to remove myself from the human trafficking scheme, and it's in my best interest, in our community's best interest, to vacate. That's the declaration. Mary Ellen actually stipulates, so she stipulates to the granting. It's not just I don't oppose, it's we stipulate to the granting of this. I take that 1 piece of paper to our designated judge. That's all he sees. And again, this is about having developed trust and quality relationships with your justice partners. This judge knows Mary Ellen. This judge knows me. We've practiced in front of him for decades so that we can go to him with just this single piece of paper and he signs it, no questions asked, and everything gets sealed. So the only thing that goes to the court, which is that one little page, not the full story, not the parade of everything that's horrible that's happened to this client, just that one page. And then that in and of itself is sealed. So that's our process in San Diego. It's a lot of behind the scenes work, but the advantage of all that behind the scenes work is it protects our clients from being re-traumatized, from the fear of their story being out in the public, from their fear that their trafficker will find out that they are pursuing this and somehow get back in touch with them, from their fear that their families are going to find out about what happened to them. A lot of our clients, their families don't know. Some do, but others don't. And so I think it's very important to recognize protecting their experience and keeping it as private as possible and limiting it as much as possible in this process is key. So we've been very fortunate to be able to work out all of our petitions and have them all stipulated to in San Diego County, with the exception of one which we basically kind of pulled back and agreed that I agreed with Mary Ellen. It was a stretch, and we had alternative ways of helping that particular client achieve some conviction relief that met that client's goals. So in terms of getting to that point, as I said in the beginning, figure out who are the leaders in your community in these areas. Who are the judges who are interested in these issues and enlist their help. There will be a prosecutor who is an expert in your jurisdiction, and see if they are motivated. If they're motivated to go after the traffickers, then they should be motivated to help the victims. It's not a big leap. And so reach out to that person, get your team together and go to the courthouse, meet with your judges and see if you can develop a protocol that will streamline this process and will help our clients be able to navigate this with as little public exposure as possible.
Mary Ellen, do you have anything to add to that?
Yeah, on the process part, I think it was huge that we went in and sat down and took some time with our presiding judge. And we were fortunate enough to do it ahead of the law, but you can do it at any time. But the sitting down and I should tell you, I'm not normally like this, right? I'm like, let's just do it and see how it works. But I really think that taking the time to educate the judge and to make decisions with the judge's buy-in, and then the judge actually brought in his court clerk. And his court clerk had opinions on how the order, what would help her, what would be in the order, should be in our order. And we did it, or the process, right? Because you don't want to make it hard on the court clerk because it's not going to get done. And without the court clerk's buy-in, it goes to the bottom of the pile. And that's what we hear in other jurisdictions here in California, right? And nothing against them. It's just, you know, you're going to take care of the workload you got in front of you and get to the hard stuff later. And then, you know, there is no later. And Kate is absolutely right about, in my opinion, if you're prosecuting traffickers, this shouldn't be too hard of a stretch, because I go back to, if I knew then what I know now, right, and I could identify the trafficker, would I use the fact that she was using drugs as part of my case, as part of the force, fraud, fear, coercion? You know, that he would give her a little bump of methamphetamine in the beginning of the night, and then she could have more later, or that he would withhold the heroin until she started feeling sick. You know, those sort of things. Would I use that? Absolutely. So then that translates into when she got wrapped up in possession cases. So I think it's all internally consistent. And I would just like to give a little bit of a shout out to our city attorney's office, who also came aboard for this process, because they handled the misdemeanors in the city of San Diego. It's a jurisdictional thing. So we've been able to collaborate together. And also certain, you know, I can see some of my colleagues from LA on the call. Working with them has also been very helpful. So I'm not just like off on my own island as a prosecutor trying to figure this out. And again, we have consistency in our responses. So I agree, try, if you can, find an expert, or at least find, and I think they're actually going that way in the LA, I don't see any LA County DAs that I recognize, but I think that's how they're going in LA. They were keeping it in each courthouse, but I think they're going towards having like a point person. I mean, anybody can, you know, make an appearance if you need it, but to have that knowledgeable person or persons makes sense, because it does seems like a waste of your time. And I know, Jamie, you get stuck in LA a lot. And it's great that you're educating people on human trafficking and how bad it is, but I don't know that you need to be doing that on every petition. I don't think that that's a good use of your time.
Well, and Rena, I'm going to give you a heads up. I'm going to put you on the spot in a second, but I think Kate has something to say. So why don't we have
I mean, I just want to be a little, I agree with everything that's been said, and certainly that's how we built the practice in New York and how we've seen it build in other places. Since this is an advanced workshop, I want us all to take a second to also reflect and think about, like, what can we refine at this point? And so, like Kate, my initial filings were ridiculously thorough, and went through, as Kate said, you know, every horrible thing that had happened to the survivors that I worked with on these. And I now have sort of started to, in conversation with the people that have been sort of through that process, think about what that is like. And so we know the connections, the things that create vulnerability in survivors' lives, right? We know the sort of, we can rattle off the red flags and the bullet points that we know create vulnerability such that people are more likely to be exploited. So in places where we do have a practice established, and where we aren't doing the same heavy lifting of getting everyone on board, that childhood rape in Alabama, maybe that stays in Alabama for the survivor. Because I know from talking to survivors as we've gone through the process that is what can intensify it to a point where it becomes untenable. And so while we know that sometimes, you know, victimization is playing off of earlier victimization and that sort of solidifying for people, again, that vulnerability, we need to think about this in each case and really reserve that kind of thorough trauma gathering for the cases where it's absolutely necessary. And I think we know that from just doing the cases and seeing where it is. And so I think that was part of what Mary Ellen was just saying. And then also one other thing to flag, which is a thing that I think about in a lot of the work that we all do, is when we have systems and process really highly dependent on one person, on a Kate Brainer, on a Mary Ellen, on a Kate Mogilescu, on a whoever, what do we run the risk of if, God forbid, something happens to us? Or are we furthering along the larger goals of educating the judiciary, educating our colleagues, making sure that this is not just situated in one person? So even though it makes perfect sense, Mary Ellen's the person, everything's going to come to her. And I wonder sometimes, are we also making some potential mistakes by situating all of the work in one person, I think in all of us, and rather than building systems that are accountable and systems that can do this and make it more accessible to people who, you know, more broadly. So these are just thoughts. This is not to say that I disagree with anything, but I think because we're at an advanced stage here, it's an opportunity to reflect and say, okay, so if Kate Mogilescu retires tomorrow, which, I mean, hi, you can hope for that to happen, right? I'm sure many people on this webinar hope for that to happen. But if that were to happen and it's all so highly dependent on one person, what have we created? So that's one thought. And then I'm sure I had more, but you wanted to call on someone, so I will stop.
If I could, to Kate's point, what we have now done in our office, and this can be in anybody else's, in any other prosecutor's office, we have things that describe what cases our unit handles, right? So if it's a gang case, it goes to gangs. Well, what if it's a gang involved rape? Where does that go, right? And so we have all that, and we've actually now added vacatur in, so it will always stay in the sex crimes unit and it's sex crimes and human trafficking. So I think, to your point, I think that's a really good thing to institutionalize it.
Absolutely.
in writing. So somebody knows they have to follow up. So when I hit the lotto and head to Tahiti, they know it's there.
And one thing to add to Kate's point is, you know, sometimes clients don't want to talk about these awful things that happen to them. You also will find the opposite of the client who's over, you know, wants to tell you every awful thing that ever happened to them. And there's a conversation to be had with your client of, you know, I'm really sorry that happened to you. You know, that we don't need to include everything in this petition in order to get this relief. And maybe we can leave that out, or when we go through this, we can discuss which things you don't want to include in the final petition. You don't have to decide that today, but having that conversation with your client is really important, because sometimes they may just feel like, I have to tell you everything. And sometimes you know, there's really awful things that aren't necessary to go in the petition. So I mentioned Rena, and Rena, I hope I don't butcher your last name, but Shandaha, because she's a city attorney in Los Angeles, and she's the point person for her office. She is one of the co-facilitators of our breakout groups. But Rena, if you are able to just jump in and talk about Los Angeles specifically, because one question that I've had is I know there was this process of seeing if things could be consolidated in LA, and I don't know where that left off with COVID. But if you're, I'm not sure if you may have stepped away during the plenary. So, oh, yeah,
No,
okay.
I'm here. I just can't turn on my video for some reason.
Oh, I think we've got everybody else turned off. Sorry about that.
That's fine. The system that we have in LA is really still in development. We've been working, like everybody else on the panel, I think, working with all of the different criminal justice partners to see what kind of systems we can put into place to effectuate the statute. And that includes trying to facilitate consolidation of cases from different jurisdictions. In a jurisdiction like Los Angeles, that's been extremely challenging. And unfortunately, one of the results has been that a lot of times it just is easier for counsel to file separate petitions, or even to ask us to stipulate to have our petition heard elsewhere. Okay, looks like I can start my video now. Okay, so yes, it's been really challenging because our jurisdiction is so large. But we're very fortunate that we have a very small unit. We only have 3 people in our unit. I'm the primary point person, and so far we haven't had so many petitions that it's escaped our control, because I do think it's really important to have trauma-informed prosecutors. And I could see if these petitions got out of hand and started going to line deputies, I could see this becoming a problem, both for our trauma-informed practices and for educating judges, and making sure that these are handled properly. We have our cases heard in front of a variety of judges, and they have been really receptive and very willing to work with us and to accept that human trafficking is complicated. These are complex cases. There are a lot of things that won't be answered. We know that a trafficking victim isn't going to be able to describe every detail of their trafficking situation 99% of the time, maybe all the time. But I think it really helps to have a prosecutor who can explain just as well as the defense attorney can explain, that there's a consensus there. And just to speak to the point that I think everyone has brought up, having trust, having a relationship, communicating, talking as early as possible, figuring out what you can agree on is so, so crucial, even if you don't have a very tight system in place. And the system that you have in San Diego, which I think is fantastic. And I don't think that system, at least at this point, could work in Los Angeles, but it's definitely something that we talk about. And Jamie, I don't think your talents are wasted in LA. We really appreciate that you come up.
Thank you. And it's been really interesting, the contrast between the city attorney's office in Los Angeles, which has Rena as the point person, and the DA's office, who doesn't have a point person. They have a point person on human trafficking cases, but not specifically a point person on vacatur. And what happens is, when we file in LA, it'll go to the deputy assigned to the courtroom where the underlying case happened. And I can tell you it's a completely different situation. We'll get into the breakouts of what happens when you walk into a courtroom where the deputy doesn't know anything about your case, anything about human trafficking, and how you move forward versus what we have when we have a city attorney case in LA where we walk in, Marina's already read everything, she knows all about the case, she's likely stipulated to it. It's a really different just environment, especially for a client, in terms of what to expect walking in the door. So we're very grateful for that. And my hope is that many more prosecutorial agencies take that approach. And this is the fastest hour of my life because we're already at an hour mark, which means it's time to go into our breakout sessions. I had more questions, but we'll get into them in our breakouts. So what I'm going to do now is I'm going to try to share my screen and hopefully get back to our PowerPoint so I can introduce our breakout session. So we reformatted our breakouts a little bit. So we're going to be breaking out into 2 different California breakout groups and then 1 outside of California. And we're actually going to have prosecutors and defense attorneys together. And hopefully that'll create a really dynamic dialogue. And as I mentioned, we have set questions for these breakout sessions. We know that many of you are coming today because you have your own questions that you want to ask, and this is a great opportunity to do that. So please, by all means, do that. Our recommendation is that you use the raise the hand function, because even with this size of group, the breakout groups are going to be relatively large, and so it just might be easier to raise hand, and hopefully you'll have a really good discussion. So, and just so you know, everyone's been pre-assigned a breakout group. Once I open the breakout groups, everyone should automatically end up in their breakout group. Know that your camera is going to be turned on, so be prepared for that. If you don't, just, yes, your camera will be turned on. You can always turn it off, but just so you know. And you will have about a 5 minutes of, go use the restroom, grab something to eat or drink. And but first, let me tell you the three breakout groups. So first, we have our amazing staff attorney, Grace Barron, who is going to be moderating California Breakout Group 1. Mary Ellen will be a part of that as well. Rose McCarr from Justice at Last in San Francisco, who started this work right about the same time as me. We've been doing it alongside ever since. And Kate DeGovia, one of our other amazing Kate public defenders, will be in this group as well. And she's with the Los Angeles County Public Defender's Office. And then the next is the California Breakout Group 2, which I will moderate with Charmin Bach, who is a deputy district attorney, a senior deputy district attorney in Alameda County. Catherine Brainer will be there as well, and Rena, who you guys all just heard from briefly. And finally, we have our outside of California Breakout Group, which will be moderated by Erin Hiltz, who manages our Vacatur program here at Freedom Thrive. So if you're doing Vacatur work, particularly as a pro bono attorney, hopefully you've had a chance to interact with Erin, who's also amazing. Kate Moglescu, who you all now know from the general session. Sarah Byrne, who is a human trafficking, who runs her law firm's human trafficking pro bono project in Charlotte, North Carolina, which is a really incredible program that her firm has actually taken this on to help survivors connect with attorneys from within and outside of her firm. And Brent Woody, who is with the Justice Restoration Center in West Florida, and is also part of the National Survivor Law Collective, which we recently formed a small group of survivor-focused nonprofits formed together. We have Carolina Holderness, who, as Kate mentioned, is an amazing deputy district attorney in Manhattan, and Pallavi Garg, who is an assistant state attorney in Miami-Dade, Florida, doing amazing work out there. So that is our breakout groups. So I'm going to stop sharing my screen, and I'm going to open the breakout rooms now, and you'll have about 5 minutes. And if you don't move into a breakout group, we'll move you as soon as we see that you're not in a group. Hello, Abigail. Are you in California or are you outside of California? Oh, you're muted.
Outside. I'm from Indiana.
Outside. Excellent. Okay, well, thank you for joining us. I'm going to send you to the non-California, outside of California group.
Great,
You're on your
thank
way. Yep. And for everybody else, I'm going to ask you if you're in California or not. I know you're in California, so I'm going to send you to a California group. Jennifer, I know you're in California, so I'm going to send you to a California group. And Arturo Martinez. Arturo, are you in California or outside of California?
California, could you draw me into Rena Shahande's group?
I certainly can.
Thank you.
You're headed that way. And Ashley, am I pronouncing your name right? Ashley Pelto? You are muted, but are you in California or outside of California? Hello.
Yeah, sorry, my connection isn't. I'm in Massachusetts.
I now see that. Sorry, I couldn't see that before, but I will send you on to the outside of California group. Thanks so much for joining us. And Ellen Atkinson. You may be muted. I think you are. Oh, you're unmuted. Are you California or outside?
I am California.
Excellent. All right. Thanks so much for joining us and sending you along. And then last, I see a 619 number. I also see Lauren Benjamin. Lauren, are you in California or outside of California? And the 619 number that's calling in ends in 053. If you could unmute yourself and I can tell you, I can find out if you're in California or not. Hello. Hello? You're unmuted now. Hello? I'm not able to hear you. Okay. Morgan, hello. We are just, it looks like your audio is connecting. Headed into our breakout groups, and I would love to send you to a breakout group, and I just need to know if you are in California or outside of California. Morgan? Morgan, Lauren, and the 619 number. Unfortunately, I'm not hearing any of you, so I don't know where to send you. Hello? Okay, I'm going to send you to the California group, Morgan. Elaine, are you still there?
I am still here.
Excellent. So I see two people still in here. I don't know why Lauren, I cannot move her.
Yes, I sent them. Okay, Morgan is outside of California. I'm communicating with her
Oh, good.
via
Okay.
chat.
And are you able to move? Are you able to move people around? Can I go into the breakout group now?
I can't move them, unfortunately, but did you assign Morgan already?
I did, but I think I may have assigned her to the wrong one. Hold on. Yep. Okay, here we go. Move to outside of California. Okay, I moved Morgan to outside of California. Hopefully that will
Okay.
work.
And I have not heard from Lauren. Okay. I think we're ready.
Okay,
keep
so I'm
going,
gonna
I'll
go. Okay, I'm gonna go in, but I don't know how to move people if they need to, if they jump in late.
I would just be on standby and greet them and let them know they can return to the main session after breakouts. Done in
Perfect.
a-
Or you can. I'm gonna turn my phone. And thank you for hitting record. I see that. I forgot to do that.
No worries.
I'm gonna go into the breakout group, but if maybe if you could stick around in here and see if more people join and just message me if they need to be moved.
Sounds good. I will do that.
Great. Thank you.
You're
Okay. Bye.
welcome. Enjoy. Bye.
Everybody, as you're rejoining the larger group, we're going to take a 5-minute break and then come back and report back from our breakouts any key takeaways. So take a minute to refresh yourself. Hopefully Kate Mogilescu is getting something to eat, and we'll get started in just a minute. All right, if you are getting yourself situated, just take another couple minute or so, and we're gonna get started. I know our out-of-state attorney group wanted to start first. So I'm looking at you, Kate and Aaron, and
Yes, we have a big storm rolling through here in Okinawa. And so if you hear thunder in the background, that is me. That's my microphone, and I apologize, but I didn't want to risk losing my internet connection and then abandoning my cool team. So are we ready to start reviewing now? Okay.
go ahead, let's jump right in.
Fabulous. So during our discussion, we spent a good amount of time talking about the need to be as trauma-informed as possible and making sure that when we are seeking the story, we let the survivor kind of control the process a bit. So if there is a survivor who does not want to talk about it, we talked about going to other resources, maybe a public defender file, maybe testimony from another trial if they had done that, to kind of gather the pieces of their story and begin to put them together so that you have to ask the least amount of questions in terms of filling in the details. And then we also talked about, like, there are of course survivors who are very, very interested in sharing all of the details. It's therapeutic for them, and we don't want to deprive them of that opportunity. So kind of making sure that the survivor has the opportunity to discuss it if they want to, or that we do the legwork on the back end to kind of take some things off their plates if we're able to. We also talked about the documents that are helpful in terms of creating something that a prosecutor can look at and go, yes, there is enough corroboration, or yes, I feel that there is a valid request for vacatur, expungement, or expunction in this particular instance. Florida had a really interesting portion of the law that required official documentation to be submitted. And of course, that raises the question of what an official document is. And it was things like an arrest report that listed them as a victim, or letters from other prosecutors from other jurisdictions that indicated that they were a victim of what was happening, and just trying to make sure that you have those things that you can bolster the timeline a little bit, because the attorney brain is so linear, and just making sure that the declaration that we have matches with the things that prosecutors have access to. Pallavi had indicated that, like, sure, including their criminal record can be helpful, but what prosecutors are able to pull is a lot more detailed than what we as survivor attorneys and public defenders are able to provide. So just making sure that the declaration matches up on that timeline, and making sure, oh, sorry, Brent just included a note that Florida doesn't require official documentation, but it has a presumption that's created by including it. Thank you for that clarification, Brent. I was taking notes and I might have missed some things. And when we are looking at, or when prosecutors are looking at those declarations, they might be reaching out to detectives or police officers who are working on the case to also get a sense of how the petitioner was acting at that point, just to see like what was going on, what was the general impression then, to further corroborate the things that are in the declaration. And one of the really interesting things that we talked about was analyzing crimes that are maybe not necessarily violent, but were also not victimless, and that it's very difficult for a prosecutor to balance protecting both victims. And so we had a reminder that I thought was very helpful, that as patient as we are with our clients, we also want to make sure that we are patient with our prosecutors, because they are balancing a lot of different things in their assessment of it. And we discussed that it's okay for survivor attorneys and prosecutors to come down on different sides of that issue, and to let the court make a determination that makes sense in a way that gives both victims the opportunity to be heard. I thought that was a really valuable takeaway message from there. We have a bit more I want to talk about. We heard about really interesting cases out in Indiana. So Indiana decriminalized child prostitution in an effort to not then prosecute children for incidences of trafficking. But instead of recognizing that those children are victims, children are instead being charged with recruitment and human trafficking themselves. And they recently had their first successful vacatur petition. The petitioner was 14 when she was originally charged with trafficking, and 16 when she had her charge and conviction eventually vacated. And that vacatur was granted about 2 weeks before COVID hit. So the hope is that as word continues to spread about this vacatur, that more people may come forward and then seek vacatur. The really surprising thing that we recognized was that the prosecutor, even though it was a blue area, was very, very opposed to the vacatur petition, and that she fought tooth and nail to try and prevent it from being signed. It was really traumatic for the client. It sounded like it was kind of traumatic for other attorneys that were in the room as well, just seeing such a vociferous refusal to accept that vacatur. And that kind of led us to talk about what we would want to see moving forward. We hope that there's continued education of attorneys and service providers and just members of the community to better understand human trafficking and the effects that it has on survivors and victims. And we want to continue working on ways to make the process for dealing with these charges for prostitution or human trafficking, to make them in a way less adversarial, because the system is so set up to be adversarial, but it's not really set up for these instances of when both sides may recognize that there's a victim in this and that they need to be protected, and that we want to get them this relief. So we talked about how important it was to create that open dialogue from both sides, from survivor attorneys and public defenders, as well as from prosecutors. And we also talked super briefly about just the need for a federal statute for relief, because it's virtually impossible to get relief for federal charges right now. and the further criminalization after having those convictions on your records has just been very disappointing. So that, in a nutshell, is what the out of California folks talked about.
Thank you, Erin. Do any of the other out-of-state co-facilitators have anything to add to the highlights that Erin captured for us? I'm seeing those. Great job. It's sounds like a really robust discussion. And how about our California Breakout Group 1?
Okay, so it says that I'm unable to start video, so I'm just going to talk right now.
Okay, we'll try to fix that.
It works now. Okay, so we had a really great discussion. I didn't have to go to any of our pre-written questions. We had a very lively group. What we started out with was talking about what information to include in a declaration, like if there's some facts that you could see as bad for your client and you're not sure how the DA will approach it, having that extra information. And so we discussed like your duty of candor to the court. As Mary Ellen said, the DA is going to do their own investigation, so it's better that they find out from you versus later on in the process. It was also really interesting to talk about how sometimes things that seem like bad facts actually could be helpful to your client's case in explaining why they were vulnerable to trafficking to begin with. So even if this thing occurred before they were ever trafficked, it could definitely link into the whole story of things. Let's see. We talked about how there's a need to really educate judges. And in LA specifically, practitioners are seeing this a lot, that they get different judges and judges aren't aware of vacatur or human trafficking. Mary Ellen and Kay Brainer have done training for judges and kind of seen a need for just general education on human trafficking as being a crime and that these people are actually victims of crime. So that was a really important piece. And later on, we also talked about that there's a difference between the definition of human trafficking on a federal level and in the vacatur law. So to kind of be cognizant of that when you're looking at cases, and instead of saying, is this human trafficking, saying, does this fit the vacatur statute, because they are different definitions. We talked about sort of what Erin was saying, being trauma informed involves respecting where your clients are at and what information they're willing to give. This can also lead to situations where you might draft a whole declaration and then your client doesn't want to file for vacatur. It's not your job to convince them to file for vacatur, and it's not your job to convince them that they're a victim of human trafficking, even if you really think they are and that the statute really qualifies them for this relief. If your client's asking for expungement, you can always do an expungement and then come back later. We talked about the importance of keeping the door open for services, because you will probably come into a lot of clients who think they're ready to start this process and then it becomes overwhelming and they're not ready to go forward right now, but they might be at a later date. We talked a little bit about drug charges and how that could be indicative of labor trafficking cases. How those cases might be a little harder to argue, but how some of them have been successful. We had some sort of specific questions about filing, how to draft a declaration, how to tie in the facts, and really focus on developing the nexus between the charges and the time period that the person was trafficked. There are some disagreements among different people about where the nexus ends and whether the nexus continues. Like if you were a victim of human trafficking, do the lifelong effects of your trafficking make you eligible for this relief, or is there some sort of cutoff point where it becomes too attenuated? And then at the end, we learned about some really cool pre-filing diversion project in LA called Project Beacon, where they're actually trying to connect people to service providers right away. And if these people reach out to the service providers, then a case will not be filed. It's limited to prostitution and prostitution-related charges right now, but that's a really cool thing that they've started. And they've also started another project for employment workforce that connects survivors to employment counseling, to try to get them really good resources to find what careers they might be interested in beyond like minimum wage jobs. So that was really cool to learn about. Like I said, everyone was very interactive and it was a really good discussion, flowed nicely.
Thanks so much, Grace. Does anybody, any of the co-facilitators from that group have anything that they wanted to add to Grace's amazing summary? No? All right. Well, thank you so much. I will do my best. I was so deep in the conversation that I feel I'm not sure I can capture everything we talked about, but I'll do my best. We also talked about the nexus and later charges down the road and what kind of how far you can go, and it really is a fact specific analysis, and it's really going to depend on. It's not really about the amount of time that's passed as much as it is about, you know, how you can explain how those charges are tied to your client's exploitation. We talked about, you know, whether or not you need to name the trafficker, and that while there's no requirement in the statute that you name the trafficker, either in the pleading or, you know, outside of the pleading in kind of discussions with the prosecutor. The prosecutors find it really helpful because then they can look them up and find corroborating evidence themselves that might really bolster your petition. And it's a really personal decision for your client, but know that, you know, there's no requirement that they name them. If your client doesn't want to, that's okay. We talked about the impact of COVID on vacatur work. And, you know, one of the key takeaways there is that the work that we are doing now with our clients is probably the least trauma-informed way that we could do this work, unfortunately, in that you can't read people's faces, you can't see how they're doing. It's not the same when you're trying to prepare a declaration with a client to be doing it by phone or even virtually. Certainly it would be better to at least be able to see your client either through Zoom or FaceTime, but it poses a challenge. And of course, with the courts closed, that poses a whole another challenge of being able to get court orders. But our prosecutors are actively working on these, and certainly at Free to Thrive, we've had some successful vacatur cases while the courts have been closed. So they're still moving along even with these challenges, which is great. We talked about pre-plea vacatur and how that differs from the affirmative defense, which for those who aren't familiar with it, in California, it's Penal Code 236.23. And we talked about, so pre-plea vacatur, meaning that, you know, before they've even pled to a crime, they are pled guilty to something that there's someone seeking vacatur. And where it really comes in is if they have an old warrant. That's probably the most common when you would see pre-plea vacatur, and we have that happen where a client has, you know, an old warrant back from when they were trafficked, and they, you know, we basically go and try to seek vacatur at that point, even though they haven't pled to anything yet. And we've had some success, and some of our prosecutors have seen that as well happen. We talked about how in that case, you know, you're only addressing that one charge. So for somebody one charge, that, you know, that would be a more efficient way to do it, but a whole long record besides that, there might still be, you know, more work that has to be done. And that, you know, the affirmative defense is another option in some cases, but the showing is different, that you have to show that you're forced by your trafficker to commit the crime. So it's a different standard, and there's certain crimes like human trafficking, for example, that are not eligible for relief under the affirmative defense, whereas they can be vacated. We talked about supplemental documents and about how, you know, which supplemental documents might be helpful. The prosecutors really, you know, emphasize that the most important thing is the client declaration, and that they're going to focus on first, but there can be some really helpful supplemental documents, things like, you know, pictures. We talked about a picture of a branding tattoo, medical records, and Kate Brand reminded us to be creative. Don't put any limits on what you're doing. Think about how you might corroborate the things that your client is saying and what records you might have to support that. We talked about trying to get fees and fines that were already paid pre-vacatur reimbursed, and Kate Brainerd is working on that. Have yet to be successful in that, but it's in the works. And this is one of those times where the legislature drafted this law, and it's something that is potentially available the way the law is written, but the practical implications is there's no system for getting reimbursed for something that you've already paid out into the system. And so as advocates, we can be really creative and see if we can get courts to find a way to do that, but there definitely are challenges because the system just isn't equipped to do that. So we'll see where that goes, but we're excited to see if we can get some of that money back for our clients. But we're reminded that at this point, the way the law is written is that we cannot either vacate restitution orders that your clients were ordered to pay, nor can we get reimbursement for restitution payments that were previously paid. We also talked about federal vacatur and the fact that it doesn't exist and that there's need for it. And there have been federal bills previously to try to create a vacatur law. None have been successful yet, but we'll keep trying. But that there may be other routes, particularly in San Diego, of we have a U.S. attorney who is very forward thinking on this issue, and there may be opportunities to advocate for your clients with federal records, either with open cases or closed cases on short of vacatur. We talked about being trauma informed and what that means and what that looks like, and we talked about how much that varies between jurisdictions, between different different people working in the system, and everybody's experience is really different. We have, the experts that we brought today are all incredibly trauma informed, but some of us have encountered people in these systems that are not trauma informed, and we talked about how we can change that, and really focusing on education of everybody involved is the most important thing. And all of us are all educators in this space doing this work, and we could all educate all day long, but there's still so many more people that we have to reach. So we'll just keep chugging along doing things like this. And then finally, we talked about post-vacatur issues, and particularly the challenge with getting a clean DOJ, which Kate talked about in the plenary session, and we delved a little bit deeper into the challenges that exist and the patience that is needed and persistence to get through that. But what we both have experienced is that the biggest challenges with the clerk's offices communicating or erroneously communicating with the DOJ or errors being on the DOJ, that the DOJ will not respond to prosecutors or defense attorneys. They will only respond to clerks. So what we talked about is, one, have a very good relationship with your court clerk, walk your vacatur order to the clerk's office and find a person in that office who knows what vacatur is and knows how to correctly input the order. Because what we've learned recently, and Grace, you know this very well because you're working on this case with me, is that with some of our cases, we were told that it was the clerks had erroneously entered the order and sent it incorrectly to the DOJ, and that's why our clients' records were not taken off of their DOJ report. So making sure that you know that the person who's filing it actually knows what they're doing with it is going to be critical. And if you have issues, if you rerun your client's DOJ and there's still things on there, you go back to the clerk's office, because that's the only place where you can get this sorted out, is through the clerk's office. For my group, is there anything that I missed or that you wanted to highlight that we haven't touched on yet? Okay. Well,
you covered it.
Excellent. Well, thank you so much to everybody for participating in this. Thank you for your robust discussion. In terms of where we go from here, I think, one thing is we need more people like the people on this call. We need more prosecutors who are trauma informed, who understand what vacatur is. Most of you come from jurisdictions where you are the point person, but we need prosecutors in agencies where there isn't a point person. We either need to find one and have that dialogue, or we need to educate the entire agency. And in our public defender's office, some offices are doing this, but many are not. And so we need our public defenders to take this on internally within their offices and have their office, just like Kate's office and others that are doing this in their agency. And we need more attorneys in nonprofits and private practice to do this as well. So for those of you who enjoyed this training, please share it with others, share what you learned, encourage them to get involved with Free to Thrive and the work we're doing. If you want us to train your agency, or you want I would love to collaborate with any of you about expanding training to other folks who may not have been a part of this training. And my hope is that this is really a launch pad for a much more interactive vacatur practice area in California, particularly. We're all learning this together. More to come on what that would look like, but my hope is some sort of regular call or Zoom meeting with practitioners doing vacatur work, so we can all meet on a regular basis and ask questions like this. If that's something that you're interested in, please let me know. It's something that my hope is that's one of the action items that we can take from today is to really have this dialogue continue, not have today be the end of this conversation. And for those outside of California, please keep bringing others into the fold with you. And just a huge thank you to all of our panelists, to all of our co-facilitators, to our amazing team at Free to Thrive who made this possible, both as facilitators and behind the scenes. Thank you all so much for helping. This is a tremendous amount of work goes into something like this, and I could not have done it without each and every one of you. So I will, if you all, we'll send out, following this, we'll send out your written materials, and you'll have our contact info. If there's anyone in particular that you want to reach out to among our speakers, we're happy to facilitate that, and just keep the dialogue going. So thank you all. We're actually done a little bit early, which for those of you on the East Coast, I'm sure appreciate, and Erin dodging a storm in Okinawa, Japan. So have a wonderful evening, and please stay in touch with us. Take care.
Thank you, Jamie.
Thanks, Jamie.
You're welcome. Thank you all. Bye.